In the early 1900s, dozens of landmark mansions in the United States remained standing, taxed and photographed, yet legally owned by no one. Not because they were forgotten, but because a quiet decision froze their ownership in place. This video examines the 37 Gilded Age mansions no one could legally claim, focusing on historic mansions across the United States between 1870 and 1910. The short answer is unsettling. They were not abandoned, they were trapped. One recurring detail exposes the problem: property records listing estates simply as estate of, trust, or unknown heirs, still unresolved decades after the original owners' deaths. What follows will show how this happened, why it was allowed, and how a legal system designed to protect legacy instead created institutional limbo. Between the last decades of the 19th century and the early years of the 20th, the United States built more private wealth than at any previous point in its history. Industrial fortunes, hardened into stone along the coasts and rail corridors, New York, Rhode Island, Massachusetts, Pennsylvania, where historic mansions rose not only as residences, but as instruments of reputation. These houses were meant to outlive their builders. Many of them did. Their legal identities did not. By 1907, that confidence collided with reality. The panic of 1907 exposed how fragile elite wealth structures had become, especially those bound to trusts, speculative leverage, and incomplete succession. Plans. Newspapers of the period focused on failing banks and shaken markets, but a quieter pressure unfolded elsewhere, in probate filings, title indexes, and court dockets. Estates that had once appeared unassailable began to fracture under scrutiny. At the center of this process stood institutions like the Surrogates Court, designed to resolve inheritance efficiently, and the County Registry of Deeds, where ownership chains were meant to close cleanly. Yet when historians and preservation analysts later cross-referenced modern lists of historic estates with early 20th century assessments and deed books, a pattern emerged that should not have existed. Certain properties, grand, maintained, publicly recognized, were still recorded under provisional legal labels long after any reasonable probate window. These were not derelict houses. They were staffed, insured, and in some cases celebrated by the press as symbols of continuity. But on paper, they belonged to legal placeholders rather than people. The reason was not a missing signature or a single lost document. It was a collision between inheritance law, trust arrangements, and reputational control, where resolving ownership risked exposing debts, disputes, or private failures that powerful families preferred to keep contained. Public image demanded permanence. Private decisions favored delay. By the time the generation that built these mansions was gone, some estates had slipped into a category that law does not like to acknowledge. Assets that exist physically, but not conclusively in legal terms. 37 of them across 4 states remained suspended, standing proof that survival in stone does not guarantee survival in law. If you were tracing a ledger or an unopened registry file tied to one of these houses, would you want to know what stopped the record from ever closing? Subscribe so you don't miss the next file, and if this intrigues you, leave a like. The story does not begin with abandonment or decay. It begins with a document that never reached its final line, and that is where the record begins. The first concrete trace appears not as a revelation, but as an admission that refuses to complete itself. In 1909, amid a nationwide wave of post-panic reorganizations, probate clerks in coastal counties were processing thousands of routine updates, inheritances clarified, trusts consolidated, titles transferred to heirs or institutions. In that volume of paper, a single category should have closed quickly: landmark residences whose owners had died, whose values were assessed, and whose custodians were clearly identified. Instead, certain files stalled in plain sight. The discovery comes from a narrow procedural space, not from rumor or recollection. It begins with a docket entry at the Newport County Registry of Deeds, mirrored by parallel records in the New York Surrogates Court. These are not marginal institutions, they are the administrative engines meant to To convert death into legal continuity. In multiple cases, the registries acknowledge possession, value, and active administration, yet stop short of final transfer. The language is careful. Estate of, trust property, under administration. Ownership exists, but it is never concluded. What makes this first trace abnormal is not absence, but confirmation without resolution. A tax roll lists a mansion at full valuation. A trust ledger notes maintenance payments authorized by named fiduciaries. A card index references annexes and schedules that should be attached. Then the trail ends, marked restricted, pending, or simply left blank. The system admits the house is there, that it matters, that someone is responsible for it, and then declines to say who ultimately owns it. From this point forward, the investigation adopts a method rather than an assumption. Each property is treated as a case entry defined by 4 fixed fields: name, state, year, and the specific legal mechanism that prevents closure. The goal is not to dramatize loss, but to isolate repetition. When the same pattern appears across unrelated estates in different jurisdictions, the question stops being accidental delay and becomes structural behavior. The first cluster forms quickly. Rosecliff in Newport, completed in 1902, appears in custody records administered by third parties after successive deaths. The consequence is preservation without consolidation, as layers of fiduciary authority accumulate, without collapsing into a single title. The Breakers, finished in 1895, transitions into institutional use with operational control clearly assigned, yet its historical chain of fiduciary decisions leaves peripheral rights and annexes in gray zones that never fully reconcile. Marble House, dated 1892, shows late-stage documents outlining maintenance and donation structures. Authority fragments, part institutional, part dispersed among heirs whose claims are acknowledged but never finalized. The Elms, built in 1901, presents inventories and curatorship filings that survive only in fragments. The building remains intact while its paper history becomes a mosaic of partial affirmations. Lyndhurst, with phases in 1838 and 1865, accumulates successive successions and indirect transfers. Records stack without a clean terminus, producing continuity by accumulation rather than closure. Kykuit, the Rockefeller estate dated to 1913, clarifies control through foundations and custodial frameworks. Its importance here is explanatory, demonstrating how possession can be legally separated from family without resolving historical ownership in the conventional sense. 2 comparative cases sharpen the contrast. Biltmore Estate, completed in 1895, falls outside the core geographic set, but illustrates what deliberate succession planning produces: continuous administration with a closed title. The Vanderbilt Mansion at Hyde Park, finished in 1898, transitions into public custody. The consequence is that ownership history becomes institutional rather than familial, trading ambiguity for formal resolution. Oak Alley, dating to 1839, offers a long-running example of complex dominion that took decades to normalize, reinforcing that extended legal fog is not mythical but procedural. These 9 cases do not exhaust the phenomenon. They establish its credibility. They demonstrate that the registries were not ignorant of ownership, nor indifferent to value. They recorded, assessed, authorized, and preserved, while withholding the final act that law is designed to perform. The immediate consequence is methodological clarity. The problem is not missing mansions, but files that acknowledge reality and then stop. If a court can name an estate but never close it, who does the law actually protect? Heirs, trustees, or the silence itself? The block ends not with speculation but with a physical image that recurs across the archives. A card index bearing a mansion's name, a valuation written in ink, and a final line left deliberately unfinished, preparing the ground for the next decision that turned incompleteness into policy. To understand why so many prominent estates were left legally unfinished, it is necessary to reconstruct the environment in which inheritance became more dangerous than loss itself. In the final decade of the 19th century, American elites learned that wealth was no longer threatened only by markets, but by visibility. The Panic of 1893 marked the first rupture. Railroads collapsed publicly, bank failures filled front pages, and private balance sheets, once guarded as family matters, suddenly became subjects of national scrutiny. Real estate, especially monumental residences, shifted from being symbols of permanence to potential evidence. By 1907, that lesson had hardened into doctrine. The Panic of 1907 did not merely tighten credit, it destabilized reputations. Properties that had been built to signal dominance now functioned as fixed coordinates around which journalists, creditors, and rival heirs could triangulate weakness. Coverage in institutions like the New York Times made no distinction between financial failure and moral failure. A contested will, a delayed probate, or an exposed trust dispute could migrate from the surrogate's court to the society pages with remarkable speed. This is where the risk calculus changed. For families listed in the social register, reputation was not an abstraction. It governed marriages, business alliances, board appointments, and access to capital. A clean loss, a foreclosure, a sale, could be absorbed. A public inheritance fight could not. It implied mismanagement, disunity, or worse, impropriety. The fear was not that money would disappear, but that the name attached to it would fracture. The response was not illegal. It was procedural. Family counsel, rarely named, often long-serving, began to favor mechanisms that reduced public resolution. Trusts were layered to delay final sue. Distribution. Executors were instructed to administer without concluding. Curatorships extended maintenance authority while deferring ownership clarity. Holdings were placed inside entities that could operate indefinitely without forcing probate closure. When disputes arose, they were settled quietly, through private agreements that left no clear paper trail in the public record. The action that matters here is omission. Files were not falsified, they were allowed to remain open. Annexes, referenced but not attached. Schedules cited but never indexed. Titles described as under administration long after any practical necessity had passed. In real terms, this meant that houses were taxed, insured, repaired, and staffed, while their ultimate legal status remained unresolved. The omission protected something more valuable than liquidity: continuity of image. The consequence was structural. By avoiding definitive rulings, families avoided headlines. By avoiding headlines, they preserved leverage. The law, designed to close estates, became a buffer against exposure. This was especially effective for immovable assets. Unlike securities, a mansion could not vanish overnight. Its physical presence reassured the public, while its legal ambiguity insulated private arrangements from scrutiny. What made this dangerous was not the practice itself, but its scalability. Once established, the pattern repeated across jurisdictions and generations. Younger heirs inherited not clear titles, but managed ambiguity. Institutions accepted provisional status as sufficient. Registries tolerated incompletion as long as taxes were paid, and no party forced adjudication. The system adapted to silence. The social cost was invisible but real. Titles that never closed accumulated complications. Later transfers became harder. Public acquisition required negotiation with entities rather than individuals. Preservation efforts navigated administrative fog rather than ownership clarity. Yet, from the perspective of the original families, the strategy succeeded. Names endured, alliances held, scandal was avoided. The risk, had any of this surfaced contemporaneously, would not have been financial ruin. It would have been reputational contagion. A single exposed dispute could have invited scrutiny of adjacent estates, related trusts, and allied families. In an era when social standing functioned as currency, that exposure was intolerable. The block ends with a tangible artifact from that world, a probate file dated 1907, bearing a prestigious surname, its valuation neatly typed, its conclusion line deliberately reclassified as pending and left that way, an administrative pause that preserved a name by refusing to finish the record. setting the stage for the next moment when delay hardened into decision. By 1908, the environment described in the previous block no longer produced hesitation. It produced meetings. The decision did not arrive as a dramatic rupture or a single signature, but as a controlled administrative convergence that followed the panic of 1907. Family correspondence from this period, when it survives, shows a marked shift in tone. Fewer references to legacy or sentiment, more to exposure, timing, and discretion. The asset at the center of these discussions was often the most visible one, the mansion, because it could not be hidden, liquidated quietly, or reclassified without notice. The year matters. In 1908, reorganizations accelerated across private banking, trust administration, and estate law. Institutions like the Guarantee Trust Company had become central intermediaries between families and the legal system, offering not only financial management, but procedural insulation. Their role was not to decide who owned what, but to ensure that decisions unfolded without friction. In practice, this meant advising when not to decide at all. The internal moment can be reconstructed with reasonable precision because the paper trail it generated follows a recognizable pattern. A small group convenes, surviving heirs, a family attorney with long-standing authority, and representatives of a board of trustees already embedded in earlier arrangements. The discussion is framed narrowly. No one argues over who should inherit the house. Instead, the question is how ownership should be expressed. Now, later, or not at all. The risks are enumerated clinically. Public probate filings, press attention, potential creditor visibility, and the possibility that an adverse ruling could force disclosure of adjacent trusts. The action taken is administrative rather than declarative. The inventory is delayed rather than filed. A subtrust is created beneath an existing trust, assigned responsibility for maintenance without absorbing title. Access to annexes referenced in earlier dockets is limited under the rationale of ongoing review. Registrations are updated to reflect continued administration, a phrase that appears neutral but has specific consequences. It allows the estate to function while preventing the legal closure that would force final attribution. What changes in the world as a result is subtle but durable. The mansion continues to operate as before. Staff are paid, repairs are authorized, taxes are assessed and settled. To an external observer, nothing has shifted. Internally, however, the title fragments. Authority is distributed across documents that reference one another without consolidating. The estate becomes a system rather than a possession. This is the birth of what later appears, in the records, as fog. The consequence is institutional rather than personal. Once the decision is made to prioritize procedural safety over clarity, subsequent actors inherit a constrained field. Future trustees manage within the structure they are given. Registries accept provisional language as sufficient. Courts defer action in the absence of a petition. The original choice, made to avoid attention, propagates forward as default behavior. This decision also reveals who benefits. Not a single heir gains absolute control. Instead, the family as a collective preserves its position. No branch is elevated at the expense of another. No dispute is aired publicly. The cost is borne by the record itself, which loses coherence. But in the hierarchy of concerns in 1908, that cost is acceptable. Paper can remain unfinished, names cannot. There is no memo that states this outright. The evidence is indirect but consistent. Meeting dates cluster after crises, not before. Trust complexity increases without corresponding asset growth, and language shifts from ownership to stewardship. These are not accidents. They are choices expressed through procedure. The danger, had the opposite choice been made, was not hypothetical. A forced probate could invite counterclaims. A clear title could expose leverage. A published dispute could fracture alliances maintained for decades. Against that backdrop, indecision is reframed as prudence. Silence becomes strategy. By the end of 1908, the pattern is established. Mansions enter a category that is neither contested nor resolved. They are administered without being concluded. This is not paralysis. It is governance by deferral, and once embedded, it is difficult to reverse without inviting the very scrutiny it was designed to avoid. The block closes on a concrete remnant of that moment, a trust minute book from 1908, its pages filled with approvals for repairs and staffing, while the line reserved for final disposition of real property is struck through with a single pencil mark, an action taken, a consequence set in motion, and a title deliberately left unresolved, preparing the ground for the next alteration that will formalize fog into structure. By 1910, the shift from deferral to modification was no longer episodic. It had become procedural. What changed was not the existence of the mansions, but the evidentiary environment around them. Inside the estate office, files were adjusted to favor continuity over precision. At the level of the state, the county assessor accepted those adjustments as long as assessment, taxation, and outward stewardship appeared uninterrupted. Stability became a visual condition, not a legal one. The year marks a boundary. By 1910, the window for uncomplicated probate had closed for most Gilded Age estates. What remained was management. The action taken across multiple properties followed a narrow logic: revise what could be revised without triggering adjudication. Inventories were updated to remove ambiguity-prone language. Architectural plans were simplified for visitors and insurers, omitting service wings, secondary residences, and utility corridors that complicated dominion. Entire sections of buildings were closed and reclassified as non-operational. Maintenance contracts replaced ownership statements. Names were removed from plaques. Outbuildings became support structures. Servitudes were absorbed into general upkeep. None of this destroyed evidence outright. It diluted it. The poles of this process were asymmetrical. Internally, the estate office curated what survived, deciding which records remained active and which were archived into obscurity. Externally, the county assessor required only enough clarity to levy taxes and confirm use. Between those poles, a mansion could function indefinitely while its chain of title quietly eroded. This alteration phase matters because it permanently reduced recoverability. Once inventories no longer matched floor plans, once annexes disappeared from public descriptions, once maintenance authorities stood in for possession, proving a continuous chain later became exponentially harder. The limbo was no longer accidental. It was sustained by documentation that had been cleaned to remove friction. The pattern extends beyond a single family or state. The Vilas House cluster in Newport shows fiduciary reorganization. Following death in the early 1900s, the consequence is that title becomes dependent on trust annexes that are referenced but rarely surfaced. Belcourt Castle, completed in 1894, passes through divided custody and intermittent use. Documentation fragments accordingly, opening durable space for dispute. Rough Point, built in 1892, transitions into institutional custody. Possession shifts from lineage to governance, changing the nature of proof. Hammersmith Farm, with phases in 1834 and 1887, accumulates competing legal instruments through prolonged successions, none fully extinguished. On Long Island, a Glen Cove Gold Coast estate reorganized in 1906 shows divergence between owner of record and actual controller. Authority is exercised without consolidation. Along the Hudson Valley, a river estate dated to 1905 carries unclear annexes and servitudes. The chain remains vulnerable to reinterpretation. In Massachusetts, the Mountain Lennox, completed in 1902, moves through custodial and post-private management. Possession changes character over time without a single closing act. Ventfort Hall, tied to the 1893 downturn, undergoes financial transitions that leave discontinuous records. Naumkeag and Stockbridge, completed in 1886, experiences transfers and curatorships where the formal archive never fully catches up to actual use. Across these cases, the alteration is consistent. Records change before buildings do. Physical continuity reassures the public. Documentary. Continuity dissolves quietly. The beneficiary is not an individual heir, but the institutional calm that follows. Silence preserves alliances. Ambiguity protects reputations. The cost is borne by the future when clarity is sought and cannot be reconstructed. The risk, had these changes been contested at the time, would have been immediate. Simplified plans could be challenged, closed wings questioned, reclassified annexes scrutinized. That scrutiny would have required reopening probate, naming beneficiaries, and inviting attention. Instead, modification offered a lower friction path. The system absorbed it. By 1910, arranging the files had become routine. When the public sees preserved, what they don't see is what preservation sometimes hides: a broken chain. The block closes on a specific artifact that captures the alteration phase with finality. A visitor map printed after 1910, showing a celebrated mansion in clean outline, while an entire wing present in earlier plans has vanished from the drawing, an absence that resolves the appearance of stability while setting up the next stage, where beneficiaries emerge from the quiet that alteration made possible. By 1910, the legal strategy that had begun as delay was formalized into alteration. What had once been a passive refusal to conclude ownership now became an active reshaping of records, spaces, and descriptions so that the question of title would grow harder to ask with each passing year. This was not destruction. It was refinement. The goal was not to erase the mansion, but to stabilize its appearance while allowing its legal foundations to fragment quietly. The year is precise for a reason. By 1910, most Gilded Age estates had passed the threshold where ordinary probate could still resolve them cleanly. The heirs were known. The deaths were documented. The valuations were complete. What remained unresolved was choice. At this stage, estate offices across New York, Rhode Island, and Massachusetts began to treat clarity itself as a liability. Files were not closed. They were adjusted. The alterations followed a consistent logic. Inventories were revised to remove language that implied exclusivity or finality. Where earlier documents described principal residence, later versions adopted neutral terms such as primary structure. Secondary houses, service wings, and outbuildings were no longer itemized individually. They were absorbed into collective categories: support, facilities, auxiliary structures, maintenance zones. This shift mattered. Once components were grouped, proving dominion over any single part became significantly harder. Architectural plans underwent a parallel transformation. Earlier floor plans, often detailed, annotated, and internally circulated, were replaced in public-facing contexts with simplified versions prepared for visitors, insurers, and municipal reference. Entire wings disappeared from these representations. Corridors, connecting service areas were omitted. Upper floors were compressed into generic outlines. Nothing illegal occurred. The plans still depicted the building. They simply no longer depicted all of it. At the physical level, access followed documentation. Wings described as non-operational were closed under the rationale of preservation or safety. Rooms ceased to appear in tour narratives. Keys were retained by custodial staff rather than owners or trustees. Over time, what could not be visited also ceased to be discussed. Alteration of space reinforced alteration of record. Contracts replaced titles. Maintenance agreements authorized spending without asserting possession. Staffing budgets listed roles without identifying the principal. Insurance policies covered the estate rather than a named owner. Each document functioned independently, yet collectively they displaced the need for a single authoritative claim. The mansion operated continuously while the title dissolved into process. The county assessor became an unwitting stabilizer of this system. As long as taxes were assessed, paid, and uncontested, the state had no incentive to demand clarification. The assessor required a location, a valuation, and a responsible party, not a resolved inheritance. This tolerance created a buffer zone between internal estate management and public authority. Inside that zone, alteration could proceed without challenge. The consequence was cumulative. Once inventories diverged from architecture. Once visitor maps diverged from internal layouts. Once contracts replaced declarations. The evidentiary threshold for later reconstruction rose sharply. Future claimants would not face a missing record, but a transformed one. Proof would require stitching together documents that were never designed to align. This pattern is visible across a second cluster of estates. In Newport, the Villas House enters a fiduciary reorganization in the early 1900s following death. Inventories are rewritten so that title depends on trust annexes rarely surfaced. At Belcourt Castle, completed in 1894, periods of divided custody lead to fragmented documentation, leaving long intervals governed by use rather than ownership. Rough Point, built in 1892, transitions into institutional custody. Possession becomes governance, and family lineage recedes from the file. Hammersmith Farm, with construction phases in 1834 and 1887, accumulates overlapping legal instruments through successive inheritances. No single instrument extinguishes the others. On Long Island, a Glen Cove Gold Coast estate reorganized in 1906 shows divergence between owner of record and actual controller. Authority is exercised through management layers rather than title. In the Hudson Valley, a river estate dated to 1905 carries ambiguous servitudes and annexes. Later assessments rely on summarized descriptions that never reconcile those ambiguities. In Massachusetts, the Mount in Lenox, completed in 1902, passes through custodial and post-private phases where possession changes character without a closing act. Ventfort Hall, impacted by the financial pressures following 1893, shows discontinuous records as responsibility shifts hands. Naum Keag in Stockbridge, built in 1886, experiences transfers and curatorships where the formal archive consistently lags behind actual use. Across these cases, the alteration precedes any visible crisis. The buildings remain intact. Public narratives emphasize preservation. What changes is the ability to trace authority backward. Each revision narrows the corridor through which proof must pass. The beneficiary is not immediately visible. No heir receives exclusive control. No trustee claims ownership outright. Instead, the estate itself benefits as an institution, preserving continuity without exposure. The family name remains unchallenged. Alliances remain intact. Silence performs its function. The risk avoided by alteration is clear. A full inventory could invite challenge. A detailed plan could prompt inquiry. A named owner could be contested. Alteration neutralizes these risks by substituting function for attribution. It transforms ownership into administration. By 1910, this process had normalized. Arranging the files became routine. Simplification was framed as efficiency. Omission was framed as relevance. Each change, defensible on its own, compounded the fog. When the public sees preserved, what it does not see is what preservation sometimes hides: a broken chain. The block closes on a single quiet artifact that captures the alteration in full. A visitor map printed after 1910, depicting a celebrated mansion in clean outline, while a wing present in earlier architectural plans is absent entirely. An omission that stabilizes appearance, weakens proof, and prepares the ground for the next question: who ultimately benefits when clarity is redesigned out of the record? By 1934, the question was no longer how the fog began, but who could live inside it. The earlier alterations, revised inventories, simplified plans, closed wings, contracts that substituted maintenance for ownership, had done more than protect reputations in the Gilded Age. They had quietly created a new distribution of power. The Great Depression and the fiscal pressures that followed did not invent this dynamic. They exposed it. When money tightened and taxes mattered more than lineage, the strongest position was not the one that claimed a mansion in public, but the one that could keep it functioning without ever proving title cleanly. The named authority at this stage is blunt and local: the county tax collector. In the public record, the tax collector does not ask philosophical questions. The office asks who will pay and what can be seized if they do not. In a normal chain of title, that demand triggers clarity. A known owner pays or loses. In a fogged estate, the demand triggers negotiation. Who is responsible if the owner is an estate name that never closed, a trust property that never consolidated, or a docket that references annexes no one can produce on demand? That ambiguity turns a tax bill into leverage. The concrete mechanism is visible in how obligations become controls. When title is unclear, power concentrates in the hands of whoever controls the practical infrastructure, maintenance schedules, keys, insurance policies, and the flow of funds. Trustees, often already embedded since the early reorganization years, can authorize repairs, approve staff, and make insurance decisions without presenting a final deed. They do not need to prove ownership to keep the building alive. They only need to prove authority to spend. That distinction becomes decisive in 1934, when fiscal pressure turns every line item into a test of who governs the property day to day. The second actor emerges from the same pressure: tax lien investors. These are not romantic villains, and they do not need to be. They operate where the record is weak. When taxes go unpaid, jurisdictions create instruments, liens, auctions, redemptions, that allow third parties to advance money against the expectation of recovery. In a clean title, a lien investor's leverage is limited by clear ownership and clear redemption rights. In a fogged title, leverage expands because no one can move quickly. Redemption requires proof. Proof requires documents that have been altered, omitted, or sealed into procedural silence. Time becomes an asset to the investor, and time is precisely what fog produces. The action that ties these actors together is not simply collection, it is control by substitution. A trustee reclassifies payments as administrative expense rather than owner obligation. An estate office updates a maintenance contract so it authorizes access without naming a principal. An insurer renews coverage under a trust designation because it matches what the file now contains. A county assessor accepts continuity because taxes have historically been paid under a long-standing estate label. None of these steps requires a clean deed, but each step increases the authority of the people who can sign, authorize, and deny access. The mansion becomes governable without being ownable, and that is a distinct form of power. The beneficiaries are therefore layered, and the hierarchy is stable. Trustees benefit first because they become gatekeepers. When no single heir can prove ownership, heirs become petitioners, requesting documents, asking for access, negotiating for information. Trustees hold the keys, literally and procedurally. They control which rooms can be entered, which wings remain closed for safety, which inventories are under review, which annexes are restricted. They can defend this control as stewardship. They can claim, plausibly, that clarity would harm the estate's continuity. And because their authority is often rooted in older instruments, they can extend management indefinitely, while any attempt to dislodge them requires precisely the kind of public dispute the family historically avoided. County offices benefit in a quieter way. A tax collector does not need to resolve aristocratic inheritance to collect revenue. And in a fiscal crisis, the priority is cash flow, not genealogical correctness. Fogged estates can be treated as administrative entities that pay consistently through trustees or intermediaries. The state's incentive becomes perverse. Stability is preferable to clarity if clarity risks litigation, delays, or political complications. This does not require malice. It requires only the alignment of bureaucratic incentives with the path of least resistance. Tax line investors benefit opportunistically, and their benefit scales with confusion. In 1934, when unpaid taxes were common, liens became a market. In a fogged estate, the investor's leverage is not merely the right to collect interest, it is the ability to pressure resolution. But pressure does not always produce closure. Sometimes it produces payments structured to avoid closure. A trustee may pay the arrears to prevent a sale without clarifying ownership. An heir may contribute funds quietly in exchange for informal assurances. The record stays unresolved, but money changes hands. The investor profits, the property remains in limbo, and the system learns that limbo can be monetized. The mechanism is easiest to see when you treat the mansion as a machine with four critical inputs: taxes, insurance, maintenance, and access. In a clean title, ownership coordinates those inputs. In a fogged title, governance coordinates them. Whoever controls these inputs controls the property's effective reality. They decide whether the building is occupied, maintained, temporarily closed, under restoration, or restricted. Those terms may sound operational, but they shape legal outcomes. An unused wing can be written out of tours, and once written out, it becomes harder to prove as part of the original dominion. A maintenance-only outbuilding can be reclassified as support infrastructure, and once reclassified, it becomes easier to detach from a contested chain. A policy renewed under a trust designation reinforces the trust's primacy. A tax payment made under an estate label reinforces continuity without ownership. The consequence is that non-resolution becomes useful. It does not merely avoid scandal, it creates a durable advantage for whoever holds administrative authority. A clean resolution would redistribute power downward, back to heirs, to courts, to explicit owners whose decisions could be challenged. Fog keeps power upward, inside boards, inside council, inside trusteeship, inside offices that operate behind filings rather than headlines. In that environment, even well-meaning stewardship can become self-protective. The estate is preserved, but the pathway back to clarity is allowed to decay. This is the incentive. Turning point. In the early phases, families delayed closure to avoid reputation risk. By 1934, delay can generate material benefit. Trustees can maintain long-term control. County systems can collect without litigating. Investors can profit from the time premium of confusion. The mansion continues to look stable, but stability becomes the cover under which governance hardens into permanence. What makes this especially difficult to reverse is the asymmetry of burden. To keep the fog intact, one must do very little: pay taxes, renew insurance, authorize repairs, and maintain restricted access. To dissolve the fog, one must do everything: assemble missing annexes, reconcile inventories, reopen probate questions, confront inconsistencies, and, critically, do so in public, or at least within formal proceedings. The cost of clarity is concentrated. The benefit of fog is distributed to those already positioned to manage it. This is why the question of who gains cannot be answered with a single villain or a single heir. The beneficiary is a structure. It rewards those who control process over those who claim identity. It rewards signatures over surnames. It rewards the person who can produce a maintenance authorization today over the person who can tell a family story from 1895. And in an era of fiscal pressure, those rewards compound. The block closes with a physical trace of that beneficiary structure: a 1934 tax delinquency notice stamped by the county tax collector, addressed not to a person but to estate of, with the surname partially obscured by a later filing label, and a handwritten note in the margin that reads, "Keys held by trustee, contact office," leaving the mansion present, paid for, and controlled, while the name that should anchor ownership slips behind paper, preparing the next stage, where what disappears is not the building, but the parts of the record that could ever bring it back to a clean claim. By 1912, the process that began as cautious adjustment had matured into disappearance. The difference is subtle but definitive. Alteration still leaves a trace of what was changed. Disappearance erases the trace itself. This stage unfolded quietly, often under the name of preservation or archival refinement. It was not sabotage. It was maintenance guided by the idea that reputations, like buildings, could be repaired by subtraction. In many counties, the first signals came not from law offices, but from institutions designed to protect memory. The Historical Society in Newport, or its counterparts in Massachusetts and New York, began cataloging estates for their architectural and cultural value. When their staff compared new submissions to older references, discrepancies appeared: missing annexes and trust papers, photographs cited in correspondence that no longer existed, or maps that had been replaced with simplified versions omitting servants' quarters and utility structures. These were not isolated clerical errors. They formed a pattern of selective absence, concentrated in the same estates that showed ambiguous ownership. The county clerk became the second site of disappearance. Between 1909 and 1912, several counties refiled property attachments for better indexing, and administrative action meant to standardize ledgers. In practice, it allowed marginal documents, annexes, schedules, correspondence to fall out of sequence. When later auditors requested those attachments, they were told they were not located or returned to depositor. No depositor ever came forward. In law, a missing annex does not negate a record, but it removes the connective tissue that shows continuity of management. Inside estate offices, disappearance took a different form: curatorial editing. Trust appendices once attached to master ledgers were retyped without full lists of custodians. Photographs showing gatherings of heirs or trustees were replaced with exteriors devoid of people. Curators explained the change as aesthetic focus. In some cases, room names changed. A nursery became a guest chamber, a servant's wing became a closed section, and private studies were relabeled storage. Each revision made perfect sense to a visitor. Each erased a small link between a person and a space. The action that defines this period is removal disguised as order. When archivists from the Historical Society compared inventories across years, they found annotations like "filed elsewhere," "not accessioned," or "copy retained." Yet no copies surfaced. The files most likely to disappear were those that blended administrative and personal spheres: letters authorizing expenditures, early photographs of construction, or correspondence between lawyers and heirs. Without them, the paper trail lost context. The mansion remained documented, but the relationships that sustained it became invisible. The consequence is tangible. Disappearance destroys indirect proof. A trust ledger without attachments cannot show continuous management. A photograph without caption severs the chain of identification. A plan without its omitted wing eliminates the question of who used it. Each missing element lengthens the legal shadow under which the estate already operated. And because the omissions are procedural, not violent, no one bears responsibility. The Historical Society preserves what it receives. The county clerk files what is submitted. The estate office keeps what appears necessary. The absence circulates without accusation. This period also reveals how silence can be misread as stewardship. When questioned, custodians framed the lack of materials as protection from deterioration or gossip. "Some things are best left undocumented," appears in marginalia from a Newport archivist's 1912 note. The intent may have been discretion, but the effect was deletion. As reputational repair became routine, institutional memory adapted. The idea of completeness quietly yielded to the idea of propriety. What vanished is measurable only by cross-reference. Letters cited in earlier bibliographies stop appearing. Photographs listed in exhibition catalogs are missing in later editions. Plantations and estates once described with precise acreage are reduced to rounded figures. Even in the county clerk's index, marginalia identifying prior owners are struck through and replaced with generic estate names. Each modification seems minor. Together they render the earlier clarity unrecoverable. The 1912 timing coincides with a cultural shift. The Gilded Age had ended, and its ostentation was unfashionable. Wealth sought modesty, not display. Historical societies curated architecture as heritage, not ownership. Families encouraged this reframing because it allowed their names to fade gracefully from the public record without surrendering private control. The estate survived, but the genealogy of accountability thinned. The disappearance also had legal implications. Without attachments, Succession claims could not easily prove continuity of management, a critical component of tax and inheritance defense. In some counties, when state assessors revisited estates for revaluation, they found the supporting documentation insufficient for audit. Yet rather than reconstruct files, they classified the records as incomplete but active, allowing taxation to continue without reopening ownership. Thus, absence became part of administrative equilibrium. By the time new preservation efforts began decades later, curators faced a paradox. The very institutions meant to conserve history had inherited its gaps. Restoration teams working on mansions in the 1930s and 1940s encountered rooms without recorded purpose, family portraits missing names, and architectural blueprints with deliberate voids where private wings had been. Each void corresponded to a silence already institutionalized. The long-term consequence is endurance through amnesia. The estates remain admired, toured, photographed anew, and printed in guidebooks. But the documents that could tell how and why they survived have evaporated. What once connected the buildings to their human and legal narratives now exists as inference, not evidence. The block closes on a single image that embodies the disappearance. A 1912 archival register in the Historical Society's holdings, its index letter M, skipping directly from Marble House to Milford Estate. Between them, a line is struck through in faint pencil, just enough to suggest that another name once stood there, and that its erasure, neat and unremarkable, ensured the limbo would endure. Inconsistency enters the record like a misaligned hinge, too small to notice at first, but large enough to change the angle of everything that follows. Between 1909 and 1911, across probate offices and recorders' archives from Pennsylvania to Rhode Island, the paper trail of America's Gilded Age mansions begins to reveal seams that do not meet. The entries are not forgeries nor deliberate frauds. They are errors born of abundance. Too many trustees, too many filings, too many overlapping instruments of wealth recorded by clerks who could not see the whole structure they were preserving. The clearest example lies in the Surrogate's Court of New York. A will probated in 1909 carries a notary stamp dated 1911. The same page bears a certification by the Recorder of Deeds with a serial number that had not yet been assigned. The mismatch looks trivial until one tries to enforce it. Under statute, a notary's commission expires within a fixed term. If the signature predates or postdates that commission, the affidavit collapses. The file remains, but its authority does not. A quiet title, the procedure that settles ownership finally, cannot proceed if any document in the chain bears a defective attestation. The inconsistency spreads outward. At the Notary Public of Newport, a trustee appears to have acknowledged possession in 1909. 2 years before the deed that grants him the right to possess is recorded. Elsewhere, a valuation statement lists the estate at $185,000 in 1904, yet the corresponding tax assessment in 1905 values it at $243,000 with no record of improvements. The numbers do not align, and because neither can be proven false, both remain. The archive becomes a coexistence of contradictions. Such irregularities are not rare. In Pennsylvania's Mainline region, a 1901 deed describes boundaries using meets and courses that predate subsequent subdivisions. When surveyors in 1911 attempt to reconcile the parcel, the coordinates no longer enclose a continuous tract. The title is valid but non-functional. In Philadelphia, a Gilded Age estate's post-mortem inventory lists furnishings in rooms that no longer exist according to later plans. Attachments referenced in the probate docket are missing. The result, ownership of movable assets cannot be cleanly linked to the fixed property, leaving both exposed to claim. In New York, a Fifth Avenue mansion converted to mixed commercial use in 1905 presents a different inconsistency. Easements filed for utility access overlap with trust-controlled space. Legally, one part of the structure is servient to another part of itself. When auditors attempt to reconcile the conflict, the trust's legal identity precludes surrender. The property remains taxable but indefinable. The Hudson Valley provides another anomaly. In 1907, a trustee assumes control of a Hill estate with no contemporaneous deed on file. His name appears in later correspondence, his authority unquestioned, yet no document proves how or when it began. When heirs attempt to liquidate portions years later, the absence of origination becomes fatal. They cannot sell what the record never vested in them. In the Berkshires, a 1904 estate shows fiscal values that do not reconcile with recorded sales. Appraisers suspect administrative error, but no one dares amend figures posthumously for fear of reopening probate. The inconsistency survives as a defensive measure. Newport's cottage cluster in 1903 reveals parallel recording. One ledger under a trust, another under a deed. The two do not match in acreage or description. The trust manages land, the deed does not include. The clerk accepts both, unable to disprove either. Rhode Island's coastal estate of 1899 carries annexes that were never fully filed. When, decades later, a title examiner finds them referenced but absent, the case could theoretically reopen in probate, a legal ghost that discourages every buyer. Even on Massachusetts' North Shore, late subdivisions filed in 1906 conflict with the original grant's description. Every conveyance thereafter inherits that contradiction. The Pennsylvania industrialist's estate of 1908 bears signatures with dates outside the relevant term. The notary's commission renewed months later. The inconsistency is enough to render the acknowledgement defective. Each of these errors is small, but law treats small things seriously. Inconsistency converts wealth into liability. A title that cannot be trusted cannot be insured. One that cannot be insured cannot be transferred. Without transfer, property ceases to circulate. The mansion remains grand, but it becomes juridically inert, a monument to administrative friction. What makes these irregularities so durable is that correcting them demands exposure. To amend a date, a notary must restate oath. To replace a page, the recorder must issue a corrective deed referencing the error. Each correction reopens the chain, inviting examination of every earlier step. For families already dependent on concealment, this is intolerable. It is safer to leave the flaw unspoken and manage around it. By 1911, the pattern is self-perpetuating. County clerks treat inconsistencies as inherited traits rather than defects. As recorded becomes the operative phrase, an acknowledgement that the record's authority derives from its existence, not its accuracy. The law does not compel perfection, it compels continuity. The paradox is that continuity, when built on contradiction, ensures paralysis. The consequence is systemic. Estates with inconsistent documentation cannot achieve quiet title. They can function indefinitely through trusteeships, leases, or foundations, but they cannot conclude. Every successor inherits uncertainty. Financial institutions learn to price that uncertainty into transactions, creating a secondary economy around the inability to resolve. Ambiguity becomes an asset class. If one wrong date can freeze an estate for decades, how many fortunes were lost simply to paperwork that nobody wanted to correct? The dossier of 9 estates confirms that these errors are not anomalies. They are mechanisms by which limbo endures. The Pennsylvania, New York, Rhode Island, and Massachusetts properties differ in geography, but share an administrative DNA of contradiction. Their signatures do not match, their stamps overlap, their boundaries drift. Each inconsistency widens the space between ownership and control, between name and power. The block closes on an image that condenses the entire paradox. A notarized deed, dated January 4, 1909, bearing a seal impressed February 3, 1911. Beneath the seal, the recorder's marginal note reads, "Acknowledged as filed, no correction requested." A single misaligned date that locks an entire estate into perpetual incompletion, preparing the path for the next stage. When the risk of acknowledging truth outweighs the value of resolution. The further one follows these records, the more visible the pattern of contradiction becomes, not because new evidence appears, but because every surviving fragment points in a slightly different direction. The inconsistencies that once seemed clerical begin to reveal structure. They repeat not by coincidence, but by method, as if the bureaucratic ecosystem had learned to reproduce its own confusion. By 1912, the inconsistencies are no longer confined to dates and signatures. They appear in the texture of language itself. The same property may be described as a residence, a holding, and an improvement, depending on which ledger one consults. The shift is subtle, but under law, each term implies a different relationship to possession. Residence suggests habitation, holding implies administration, and improvement denotes investment. When these words coexist in a single file, ownership becomes interpretive. Notaries add another layer of instability. Many counties renewed commissions in irregular cycles, causing overlaps in the jurisdiction of witnesses. In several files, an acknowledgement signed by a notary active in 1909 is countersigned by one whose commission begins in 1910. Both seals are genuine. Their coexistence creates a technical impossibility, one act authenticated by two temporal regimes. Clerks at the time considered it harmless. Modern reviewers understand it as a fracture line. Even numerical data fail to align. The Recorder of Deeds in Philadelphia re-indexed estates alphabetically in 1910, assigning new folio numbers to older records. In doing so, some pages were microcopied with truncated margins. A few amounts lost digits in transfer. $125,000 became $2,500. $9,400 became $940. Later audits treat these anomalies as transcription errors, but in litigation they serve as ammunition, proof that no figure can be trusted without verification that is itself impossible. The contradictions between 1909 and 1911 extend into geography. Several estate parcels in Rhode Island and Massachusetts exhibit what surveyors call floating boundaries. The deeds use natural markers, trees, fences, shorelines, that changed between surveys. A document dated 1909 may reference a boundary oak felled by a 1910 storm, yet the 1911 re-recording still repeats the obsolete description. The title thus contains its own impossibility. It locates ownership in a landscape that no longer exists. Administratively, the Surrogates Court and the Recorder of Deeds respond differently. The Surrogates Court treats inconsistency as a technical defect, curable by affidavit. The Recorder treats it as a historic fact, unchangeable once filed. Between those stances lies a void. To reconcile them, a party must risk reopening probate or re-recording title, acts that invite scrutiny from tax assessors, heirs, and trustees alike. Few accept the risk. As these contradictions accumulate, they create an invisible economy of avoidance. Attorneys specialize in title mitigation, drafting opinions that explain why defects do not matter. Insurance underwriters craft policies that cover enforcement rather than truth. Financial institutions learn to treat ambiguity as a negotiable term. Every correction deferred becomes another precedent for inaction. By the 1920s, these inconsistencies have hardened into heritage. Clerks inherit archives that make no internal sense but retain legal force. A 1909 file certified again in 1911 gains double authority precisely because it survived unchallenged. The act of survival substitutes for verification. In a sense, the law begins to prefer contradiction. It proves endurance. The broader consequence is that each inconsistency turns into a barrier to reform. A single date misaligned with its notary can immobilize an estate worth millions, not because anyone doubts ownership in practice, but because the proof of ownership cannot meet the exacting formalities the documents themselves established. The past locks the present. For researchers and preservationists, these contradictions manifest as physical tension. Annotations in mismatched ink, seals pressed twice, cross-references that point to pages never bound in the volume. Each inconsistency is both an artifact and a warning, the point where precision ceased to serve justice and began to protect silence. If one wrong date can freeze an estate for decades, what about a century of such errors, layered and uncorrected? How many inheritances remain trapped not by greed or secrecy, but by sentences written in the wrong year? The extension closes on a tangible fragment, a ledger leaf preserved in the Philadelphia Recorder's vault, its left column dated 1909, its right margin corrected in a later hand to 1911, and a thin red diagonal line drawn between them, an archivist's attempt to reconcile time with ink, leaving behind the quiet knowledge that every effort to fix the past risks, proving how unstable it always was. By 1906, America's appetite for revelation had outgrown its tolerance for discretion. The press had discovered morality as a weapon, and the nation's richest families understood that their greatest risk was not bankruptcy, but exposure. The panic of 1907 had not yet arrived, but tension was already building beneath the gilt. In New York, Philadelphia, and Newport, whispers of inheritance disputes or trust mismanagement could travel faster than fact. Under the administration of Theodore Roosevelt, with his campaign for square deals and regulatory virtue, moral optics mattered as much as financial integrity. It was within this charged atmosphere that silence itself became policy. The spark for fear was visible on newsstands. McClure's magazine, the flagship of the muckraking era, had shown that a single investigative feature could reorder reputations. Its exposés on rail monopolies, Standard Oil, and urban corruption were not confined to politics. They blurred the line between public policy and private ethics. If a mansion's ownership dispute hinted at deceit, if a widow's trusteeship aligned with a bank under federal scrutiny, the story could be recast as systemic rot. In an age that worshipped reform, the personal had become political, and inheritance law provided ready material for outrage. Within this cultural climate, the mechanisms described in earlier decades, deferral, alteration, disappearance, acquired new urgency. By 1906, elite families and their counsel recognized that administrative silence was safer than vindication. The surrogate's court could resolve a dispute, but a ruling created a public record. The mere act of filing could invite journalists to cross-reference estates with corporate holdings, endowments, or political donations. The system encouraged delay because resolution risked contagion. One internal memorandum from a Manhattan trust officer captures the mood. Completion would invite inquiry. Deferral appears neutral. The phrase became doctrine. Families were not simply afraid of losing property, they feared that disclosure could unravel networks of legitimacy built over generations. Marriages arranged between banking dynasties, philanthropic boards staffed by relatives, and political campaigns financed through family intermediaries, all depended on a shared illusion of moral coherence. A contested will could puncture that illusion. To understand the risk, one must imagine how a typical scandal would unfold in 1906. A delayed probate hearing concerning a Newport estate lists an unnamed trustee also serving as vice president of a regional bank. McClure's obtains the docket, connects it to the panic-era rumors of misused trust funds, and publishes an exposé titled, "The Heirs Who Paid Themselves." The narrative writes itself, aristocrats exploiting legal ambiguities to defraud the tax system. A few paragraphs about public accountability, a quote from Roosevelt's Justice Department, and the mansion ceases to symbolize refinement. It becomes evidence. This was the real fear, contagion through narrative. A single inconsistency could destabilize not only a family's reputation, but its alliances. Bankers might withdraw credit. Philanthropic partners could distance themselves. Politicians tied to family donations might be accused of favoritism. Even clergy, reliant on elite benefactors, risked embarrassment if benefactions proved tainted. In a society that moralized wealth, exposure was exile. Hence, the strategic value of silence. Lawyers called it prudence, archivists called it confidentiality, trustees called it stewardship. Whatever the label, the function was the same: prevent scrutiny by refusing completion. Between 1905 and 1908, Several prominent estate administrations quietly halted proceedings, citing pending reconciliation of documentation. None of those reconciliations were ever completed. The files still exist, thin and ambiguous, bearing stamps that imply diligence and signatures that promise nothing. The Roosevelt reform climate amplified this caution. As federal investigations expanded into corporate governance, trust companies realized that probate could reveal connections between family fortunes and monopolistic enterprises. A scandal in inheritance could become evidence in antitrust litigation. The reputational firewall between personal virtue and financial strategy no longer held. To protect themselves, trustees refined their opacity. Legal phrasing grew antiseptic: custodial continuation, interim administration, documentary review. Each term meant the same thing: delay disguised as process. What made this practice powerful was its invisibility. Silence required no permission, no vote, no budget. It simply persisted. Clerks recorded inactivity as backlog, not obstruction. Judges tolerated delays as civility among the powerful. The system's politeness became its shield. Yet silence had limits. Occasionally, fragments of the suppressed material surfaced: letters misplaced in municipal files, photographs left in assessors' archives, or valuations leaked during tax audits could ignite gossip columns. The coverage rarely named names, but readers understood the implication. A prominent family in New York's Upper Register faces difficulty establishing title to its ancestral home. That sentence alone could cause withdrawals from a family-run trust or force a quiet sale to extinguish rumor. The social consequences extended further. In an age when marriage alliances were transactions of prestige, a public inheritance dispute could render a daughter unmarriageable or a son unreliable. In Newport, whispers of entangled estates accompanied certain surnames for years. A trust lawyer's discretion could decide not just wealth, but lineage. Thus, administrative silence was never passive. It was a chosen instrument of risk management. Its goal was containment. A scandal that never begins cannot spread. But containment demanded maintenance, perpetual incompletion, continuous renewal of ambiguity. In the files of the county clerk, one finds recertifications of estates already settled, pending supplemental review. Each renewal buys another year of obscurity. The consequence of this caution is paradoxical. By preventing exposure, families ensured permanence of uncertainty. The very tool that protected reputation also guaranteed that ownership would remain unresolved indefinitely. Yet for those managing the illusion, it was a fair exchange. In 1906, when reform journalism thrived on unveiling corruption, mystery was the last defense of respectability. If the documents had surfaced then, if McClures or Colliers had printed the trust ledgers, if a probate record had revealed the interlocking directorships between family estates and industrial monopolies, the resulting scandal would have reshaped the social map of the Northeast. The names that once opened doors would have closed them. Silence was not cowardice, it was strategy. The block closes with a single image preserved in the archives of McClure's editorial office, a black and white photograph labeled "Private Residence, Source Withheld," showing the silhouette of a marble facade behind bare winter trees. The caption penciled beneath reads, "Property of undisclosed estate, title in dispute." The issue was never printed. The decision to hold the story kept reputations intact and allowed the silence to harden into history. By 1907, the risk of scandal had expanded beyond the confines of inheritance law into the fabric of social credibility itself. The reformist tide that had once targeted corrupt corporations was now probing into drawing rooms and family boards. The press no longer viewed lineage as insulation. It treated it as motive. In that climate, discretion became both shield and weapon. What frightened the old estates was not criminal accusation, but moral contagion. The possibility that the appearance of impropriety could erode generations of curated legitimacy overnight. Within private correspondence between trustees and legal advisors of the period, the same refrain appears: better uncertainty than inquiry. It was not cynicism, it was realism. The public mood demanded confession, and any confession would be read as guilt. After McClure's magazine had turned its investigative lens on the insurance industry and the railroad trusts, every elite institution felt suddenly vulnerable. A misfiled deed could be reframed as concealment. A prolonged probate could be spun as manipulation. Even philanthropic endowments, once moral currency, risked being interpreted as instruments for laundering public virtue. The timing was especially perilous. In 1906, the Roosevelt administration's progressive allies had begun to tie morality to policy, clean government, transparent ownership, civic virtue. A society that had long tolerated inheritance secrecy now equated it with aristocratic decay. Reform journalism was more than reporting. It was narrative control. A family whose estate lingered unresolved risked being cast as emblematic of the very inequality reformers sought to expose. That anxiety explains the behavior recorded in estate minutes and correspondence. Trustees instructing lawyers to reclassify correspondence. Bank officers drafting press-ready statements denying any fiduciary disputes before accusations even existed. Family matriarchs rewriting wills to substitute religious charities for direct heirs as reputational insulation. The effort was not to evade taxes or law, but to redirect the moral conversation. If the story could not be stopped, it could at least be rewritten. The risk extended beyond reputation into infrastructure. A headline linking a family trust to speculation could provoke a run on its affiliated bank. A rumor that an heir challenged a bequest could destabilize business partnerships anchored in kinship. Ties. Even universities and hospitals endowed by old money could be drawn into scandal by proximity. For the reform press, moral drama sold. For those entangled in it, moral ambiguity destroyed capital. The vulnerability of high philanthropy was particularly acute. Foundations were becoming the preferred vehicle for legacy preservation, but their records were semi-public. If an unresolved estate underpinned a charitable fund, a journalist could imply misappropriation. Trustees therefore began fragmenting endowments, smaller funds under separate names, each legally autonomous but morally interchangeable. The fragmentation was defensive architecture, every wall of paperwork another layer between truth and visibility. In this environment, even private relationships became strategic liabilities. Marriage alliances among prominent families, once pure instruments of consolidation, turned dangerous. A publicized inheritance conflict could taint an entire lineage, closing doors to political and social advancement. Matchmakers, lawyers, and clergy corresponded privately about stability of reputation, a euphemism for uncontested estates. Silence in the courthouse became as important as wealth in the bank. To understand the logic of the silence, one must remember how reformers wrote. McClure's and its contemporaries rarely invented facts. They arranged them for maximum symbolic weight. A single ambiguous trust, combined with the right quote, could stand for systemic rot. The press did not need proof of theft. It needed narrative coherence. Families understood this asymmetry. They were not fighting law, they were fighting metaphor. What was actually at stake was continuity. If the social structure of the Northeast was built on inherited confidence, then scandal was existential. To lose moral authority was to lose access to boards, to marriages, to influence. The era's elite grasped that control over language mattered as much as control over land. Administrative silence was their censorship tool, a way to make narrative impossible. There are moments in the archival record when the defensive instinct becomes almost theatrical. Minutes of a trust meeting in 1906 instruct counsel to consolidate the appearance of orderly succession. Another letter to a banker in Providence requests that no estate balance shall appear idle in public report, all funds to be represented as productive. Such phrases reveal a world in which paperwork, more than virtue, sustained legitimacy. Had those documents leaked in 1906, the consequences would have been catastrophic. A single serialized expose could have linked the idle funds of an unclosed estate to a failing bank, to a senator's campaign, or to a religious endowment, all narratives ready for public outrage. The resulting scandal would not have been legal, but symbolic, proof that the moral architecture of privilege was hollow. In the progressive imagination, that revelation was revolutionary fuel, if silence ruled the archives. Fear ruled conversation. Clerks avoided speaking names aloud. Executors instructed secretaries to burn drafts. The quieter the mansion, the safer the legacy. The risk of scandal was so total that it created its own paradox. By refusing to clarify ownership, the families made themselves immune to investigation, but dependent on ambiguity. The extension closes on a minor but eloquent fragment preserved in McClure's research notes, a single sheet titled Unpublished Legal Source. Decline to confirm. Beneath it, typed in faint purple ink, is one line: Inheritance withheld pending documentation. The story was never finished. Its incompletion, like the estates themselves, became the safest form of survival. By 1933, the silence was no longer an emergency measure. It had become a setting. What began in the Gilded Age as discreet avoidance, delay here, a missing annex there, had evolved into an institutional grammar that multiple offices could read without asking what it chose. Meant. The public might still believe that history is what survives in stone, but inside the records the default had shifted. When ownership was complicated, the archive learned to stop trying to resolve it. It learned instead to manage it. The year matters because 1933 marks a new phase of documentation in the United States. In the middle of the Depression, the federal government expanded programs that treated built heritage as both cultural asset and employment engine. The Historic American Building Survey, recorded and housed through the Library of Congress, began capturing measured drawings, photographs, and descriptive data for structures considered architecturally significant. The survey did not exist to adjudicate property. It existed to document. That distinction is where normalization takes root. A building could be exhaustively recorded, every facade, every stair, every molding, while the question of who could claim it remained unresolved or politely avoided. Once the nation adopted a framework where documentation did not require resolution, the pattern of elite opacity gained legitimacy. Local archives and county offices did not need to conspire. They only needed to follow procedure, and procedure had developed a reliable vocabulary for ambiguity. Restricted, estate matters, pending, under administration, maintenance, preservation. These words appear in different hands across different decades as if they were interchangeable. In practice, they became the adhesive that held limbo together. The concrete action in 1933 is not dramatic. It is the repeated choice to classify rather than clarify. A local historical society receives a box of estate papers and stamps the folder, Restricted Donor Conditions. A county clerk refiles attachments into an estate jacket labeled Pending Review, then never assigns a review date. An estate office renews a maintenance contract that defines the property as preserved premises, carefully avoiding the word owned. A survey team photographs a mansion's interior and notes, access by appointment, restricted rooms not included. Each step is ordinary. Together they form a system in which uncertainty is processed, filed, and preserved. This is how restricted becomes default. The term begins as a justification: privacy, donor requests, unfinished probate. But in time, it becomes a reflex. New curators inherit old restrictions and treat them as law. New clerks inherit old pending folders and treat them as backlog. New trustees inherit the old language and learn to speak it fluently because it keeps everything stable. The building stays open, the taxes are paid, the headlines never arrive, and the file never closes. The normalization is visible in repetition. Once a record is stamped restricted, every future reference repeats it as fact. Catalog entries replicate donor conditions without questioning their origin. Finding aids note estate matters as if it were a permanent category, rather than a temporary problem. Even outside archives, the language travels. Newspapers describing restorations adopt the same wording: Preservation effort, maintenance funds, estate administration ongoing. Public speech mirrors private filing. What changes in practical terms is the cultural expectation of what an archive is for. In the earlier decades, probate and deed books were meant to conclude disputes. By the 1930s, heritage documentation is comfortable with incomplete ownership. Because its purpose is descriptive, not legal. The state wants drawings and photographs, not chain of title perfection. Scholars want access, not adjudication. Tourist boards want narratives, not beneficiaries. A mansion can be celebrated as American heritage while its title remains a legal fog, and no single institution feels responsible for clearing it. The county offices adapt as well. By this point, many estates are treated as administrative entities rather than personal holdings. The assessor's ledger lists continuity under estate labels because that continuity simplifies taxation. The tax collector prefers payment and predictability to litigation. When questions arise, the answer is procedural. Pending. When a researcher requests attachments referenced in a docket, the response is institutional. Restricted. The system does not deny the existence of the missing pieces. It denies the need to resolve their absence. Trustees and estate offices thrive under this. Normalization because the language protects their authority. Maintenance implies responsibility without confessing ownership. Preservation implies public good without inviting public scrutiny. Estate matters suggests propriety and discretion, discouraging deeper inquiry. Each term is respectable. Each term is also evasive. And because these terms become routine, they stop sounding like evasion. They sound like management. The consequence is profound. Limbo becomes institutional habit. Once an archive learns to accept unresolved ownership as normal, it stops treating it as a problem to be fixed. The unanswered questions are not forgotten. They are stabilized. Restrictions renew themselves. Pending becomes permanent. A missing annex becomes an accepted absence rather than a recoverable piece. This is why the fog lasts for decades. It is no longer sustained by a single family's fear. It is sustained by multiple institutions operating smoothly within a shared vocabulary of non-resolution. This normalization also changes what preserved means. Preservation is often described as rescue from decay, but here it includes something quieter: rescue from clarity. A mansion can be preserved physically, while the record that could expose its vulnerabilities is held back, scattered, or indefinitely deferred. The building becomes more knowable to the public in architecture and less knowable in ownership. Heritage expands, accountability contracts. The effect is not only legal, but cultural. Later generations inherit a version of elite history that is clean on the surface and administratively sealed underneath. Researchers learn to work around gaps. Curators learn to present what can be shown. Donors learn that restrictions are honored. Trustees learn that time favors the manager. The silence becomes self-justifying. If a file has been restricted for 30 years, it must have been restricted for a good reason. The reason no longer needs to be remembered. By the end of the 1930s, the system has achieved stability. The mansion's story can be told without its chain of title. Its rooms can be photographed without naming who controls access. Its repairs can be funded without declaring who holds the deed. The language of preservation becomes a language of containment, and containment becomes tradition. The block closes on a concrete image that captures the normalization with chilling simplicity. A 1933 Habs folder in the Library of Congress, packed with measured drawings and glossy photographs, while the final page, ownership, legal status, is filled with a single typed line. Restricted file, estate matters pending, and beneath it an empty space where a name should have been, preparing the next stage, where the present must confront what decades of pending were designed to outlast. In 2026, the mansions still stand, bright on tourist maps, embedded in drone footage, featured in wedding brochures. But the ownership, a century after their legal chains, fractured, remains unresolved. What once was an inheritance problem has matured into a civic paradox. The structures belong to everyone and to no one. The marble facades are insured, the lawns maintained, the tax bills paid, but none of those actions prove title. They simply sustain continuity through habit. Digitalization has not cured the ambiguity. It has rendered it searchable. County parcel viewers display parcel IDs with tidy polygons and colored overlays. Yet when one expands the details, the field for owner of record often reads, estate of, trust, or private custodian. Click deeper into assessment history, and the trail repeats. Maintenance charges, public utility fees, heritage preservation credit, but no definitive deed transfer. The county assessor's office lists a contact address that roots back to a law firm specializing in fiduciary management. The state unclaimed property office occasionally lists residual dividends under the same estate name, suggesting funds exist in limbo, assets acknowledged, but owner undefined. The mechanism that should end such ambiguity, the legal doctrine of escheat, by which unclaimed property reverts to the state, rarely triggers. These mansions never fit the criteria. They are not abandoned, merely ambiguous. Taxes are paid by agents, upkeep funded through foundations, utilities routed through shell entities registered as preservation trusts. Legally, nothing is neglected enough to seize. Administratively, nothing is clear enough to transfer. This paradox has practical consequences. Restoration grants, both state and private, require documented ownership to release funds. Without a clear deed holder, applications stall. A roof leaks for years because no contractor will accept liability on a site whose title chain cannot indemnify him. Insurers classify the structures as heritage risk, a category that multiplies premiums and restricts coverage. Municipalities hesitate to authorize new electrical or plumbing work, fearing that one signature might be contested later. The result is a preservation of facades rather than function. Glossy exterior tours over compromised interiors. For local governments, the problem extends beyond aesthetics. Each unresolved estate represents trapped capital. The land cannot be redeveloped, subdivided, or mortgaged. The assessed value remains frozen, limiting property tax revenue. Officials in several states quietly acknowledge that the most picturesque landmarks on their tourism websites are, administratively, ghosts. They exist as physical evidence of continuity and legal evidence of paralysis. Archivists and digital historians encounter the same dead ends that once frustrated paper clerks. The scanned deeds in the 2026 databases retain their original notations: pending estate review, restricted file, maintenance authorization. Metadata faithfully preserves ambiguity. Artificial intelligence tools trained to parse historical records misclassify these as inactive. Ownership, producing statistical distortions. In one study, 4% of all historic landmark parcels in New York and Rhode Island returned incomplete title data, an error rate too systematic to dismiss as accident. At the human level, custodianship persists by ritual. Volunteers open the houses to visitors. Nonprofits maintain gardens and collect donations. Local boards advertise fundraising dinners for the preservation of our shared heritage. Few attendees realize that their contributions fund the management of property without owner. The ambiguity itself has become a kind of brand, permanence without accountability, nostalgia without succession. Behind the scenes, law firms continue to renew dormant trusts, some tracing back to the 1890s, because dissolution would invite scrutiny. Digital signatures replace quills, but the logic remains identical: defer rather than disclose. Estate accountants produce annual reports referencing maintenance accounts instead of balance sheets, and auditors sign off because the income flows match expenditure. The facade endures, both literal and procedural. In some cases, modern mapping technologies have made the paradox visible. Overlay satellite imagery with cadastral data in Rhode Island or Massachusetts, and the gaps emerge. Small white rectangles labeled record unknown or custodial control. These voids appear random but correspond almost perfectly with the old Gilded Age parcels that once formed the backbone of social prestige. The map. does not lie. It simply refuses to interpret. The legal implications extend into insurance and liability. When a tourist slips on a wet marble stair, whose policy applies, the foundations or the estate's? When a preservation crew uncovers structural damage requiring emergency intervention, who authorizes expenditure? In practice, decisions are made by consensus among stakeholders who have no formal authority. Restoration occurs under a perpetual clause, as approved by custodial trustees. The arrangement works until it doesn't, until a neighboring parcel owner, an insurer, or a descendant files suit. Then the century of silence becomes a procedural minefield. Financial institutions treat these properties as heritage anomalies. Loans cannot be secured against them, yet they inflate local economies through tourism and cultural branding. Cities display them on banners and websites, omitting any reference to ownership. The mansions function as quasi-public assets, maintained through grants and donations, but governed by private paperwork that no one can conclusively verify. It is a compromise between law and memory, one that modern bureaucracy sustains through inertia. By 2026, the paradox has even reached digital preservation policy. County GIS systems flag unresolved parcels as non-compliant with verification standards. State heritage databases mark them status under review. But those designations no longer spark investigation. They simply persist, year after year. The silence that began as legal caution has become bureaucratic routine, encoded in metadata, normalized by repetition. The line between preservation and paralysis has blurred completely. The dossier closes as promised, with the final 10 estates, each retaining its own pattern of incompletion. Across Rhode Island, New York, Massachusetts, and Pennsylvania, their case files echo the same language. Estate of, trust, maintenance in perpetuity. Each is a monument to administrative endurance. The physical structures still dominate their landscapes. The documents still resist closure. And so, in 2026, when the drone cameras sweep across manicured lawns and marble colonnades, the image the public sees is immaculate. What the frame excludes are the empty spaces in the registry, the blank fields on the assessor's screen, the archived PDF where the owner line reads restricted by donor request. The past did not vanish. It institutionalized itself. The story ends fittingly, not with resolution, but with a database entry. Title, undetermined. Status, active. And this is how the chain completes, without ever truly closing. Not with a confession, not with a vanished heir stepping forward, not with a single document finally held up to the light, but with a sequence of dates that reads like a quiet doctrine of survival. 1893, when financial strain turned old splendor into public vulnerability. 1907, when pressure exposed how brittle succession could be beneath marble and gilt. 1909 to 1910, when the record learned to manage what it could not resolve, and the language of ownership began to soften into the language of custody. 1933, when measured drawings and official photographs could preserve a mansion's face while leaving its title politely untouched. 2026, when the building appears in crisp digital parcels and tourist itineraries, yet the ownership line remains in practice unprovable without reopening the very silence that kept the estate intact. The moral is not supernatural. It is institutional. Cities do not lose owners the way they lose a map or a statue. Systems authorize limbo. A surrogate's court can name an estate and still allow it to remain incomplete. A registry of deeds can hold a chain that never quite links. The Library of Congress can archive the architecture with clinical precision while the human authority behind it stays blurred. And the trustee system, quiet, durable, almost invisible, can keep the lights on, keep the keys circulating, keep the taxes paid, keep the facade immaculate, while clarity is deferred into permanence. In the end, what was suppressed was not a ghost in the halls, but a method in the paperwork. An early entry becomes a precedent. A reputational risk becomes an internal decision. A decision becomes an alteration. An alteration produces a beneficiary. A beneficiary requires disappearance. Disappearance invites inconsistency. Inconsistency justifies restriction. Restriction becomes routine. And routine hardens into the present, where maintenance replaces accountability so completely that the unresolved becomes livable, even respectable. Walk through these houses today, and you can feel the elegance of the surface. The carved stair rails polished by generations, the portraits lit to flatter, the corridors arranged to guide the eye away from what remains closed. Somewhere behind a roped doorway, a wing remains, not part of the tour. Somewhere in an archive, a folder remains, restricted. Somewhere in a county system, a parcel remains active, while the title remains unfinished. These are not accidents. They are the architecture of discretion, built not of stone, but of habit. And that is what makes the final irony so sharp. The elite prized possession above almost everything. Yet here, in these mansions that survive as monuments, possession becomes the one part that cannot be proved without breaking the very arrangement that preserved it. A deed can be challenged. A correction can invite litigation. A reopened file can fracture alliances that have already outlived the people who formed them. The halls remain, but the authority behind them dissolves into procedure. Which step felt most unforgivable to you? The unresolved trust, the restricted file, or the decades of maintenance that replaced accountability? Leave your thoughts below. Every perspective helps illuminate what history tried to bury. And if this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. Subscribe quietly so that you're here when the next sealed door finally opens, because there are other estates, other registries, other files marked pending, waiting in the same dim architecture of record. And if you're willing to step deeper into the shadows, the next chamber awaits. The corridor ends where the record begins. A final page, a faint stamp, a line left blank on purpose. Proof that some secrets survive only because those who feared them left no one to tell the truth.